Let's go on to motion 4. The state seeks to preclude the defense from making any reference to any civil lawsuits or claims that Mr. Grosskreutz and the families of Mr. Rosenbaum and Mr. Huber may or not be pursuing against anyone as a result of the defendant's actions. The state asserts that such claims or lawsuits have no bearing on this case or the credibility of any witness. And so this is kind of interesting because Gaige Grosskreutz, through the wisdom of his esteemed attorney, Kimberly Motley, filed a lawsuit right during the trial. And now the fact that he has filed this lawsuit is becoming an issue. Under the Confrontation Clause of the Sixth Amendment, a defendant is guaranteed the right to confront the witnesses against him. Delaware versus Van Arsdale. A criminal defendant exposing a witness's motivations, bias, or prejudice is a proper and important function of the constitutionally protected right of cross-examination. The bias or prejudice of a witness is not a collateral issue, and intrinsic evidence may be used to prove that a witness has a motive to testify falsely. Defendants' opportunity to explore the subjective motives for the witness's testimony is a necessary ingredient of a meaningful cross-examination. So in other words, by filing your lawsuit, you have opened yourself up for a claim that your motives are not pure and that you're likely to lie on the stand because you have money at stake here. Kimberly Motley, maybe it would have been a better idea to wait until after the trial to file the lawsuit. The range of extrinsic evidence that may be introduced to prove bias or prejudice is broad and includes a witness's civil lawsuit that is related to the criminal lawsuit at hand. So he cites State versus Johnson, who basically states that, yeah, you could bring the fact that a witness has filed a civil lawsuit in testimony. Defendant could introduce evidence of a state's witness filing a civil lawsuit, but state could not bolster a witness's credibility through the civil lawsuit without first being attacked by defendant. McCall, at pages 35 through 37, defendant could bring evidence of state's witness having 3 pending criminal charges dropped by state before testifying at trial. I'm not sure I see the connection there, but okay. The defense would also draw the state's attention to Wisconsin J.R. Criminal 300 credibility of witnesses. According to that jury instruction, in determining the credibility of each witness and the weight the jury gives to the testimony of each witness, the jury must consider whether the witness has an interest or lack of interest in the result of this trial, bias, or prejudice. If any has been shown, possible motives for falsifying testimony and other facts and circumstances during the trial which tend either to support or to discredit the testimony. Something wrong with that independent clause there. It doesn't seem to have a verb. Let me read that again. Possible motives for falsifying testimony and other facts and circumstances during the trial which tend either to support or to discredit this testimony. Now, there's no verb there. That's not an independent clause. Can't use a semicolon. Come on, Mark Richards. Get with the program. The estate of Anthony Huber and Gaige Grosskreutz have filed civil lawsuits, and Gaige Grosskreutz has filed a notice of state law claims by the Kenosha County Clerk's Office against the City of Kenosha and the Kenosha Police Department requesting $10 million. Both have great financial interest in seeing the defendant convicted and establishing the defendant's actions as entirely illegal. Evidence of these civil lawsuits clearly speak to their motivations, bias, and prejudice against the defendant, and a jury must be allowed to consider these lawsuits in assessing their credibility. Now, I'd be kind of interested in seeing the counter-argument to that, but that looks pretty convincing. And again, the timeliness of these lawsuits may really work against the prosecution here. John Huber is listed as a potential witness. I highly doubt he ever takes a stand on anything, but if he does, his own lawsuit looks like it would be an issue here. I just find it funny that upon the advice of his counsel, Kimberly Motley, Gaige Grosskreutz filed a lawsuit that could come back to bite him in the ass while he was on the stand. depending on whether the judge grants this motion. Do you think that this motion will be approved, granted by the judge? In the comments below, let me know what you think. Like my video and